The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, ladies and gentlemen, and welcome to this IT governance webinar on the first steps towards GDPR compliance. My name is Alan Calder. I'm going to be your host this afternoon. I'm the founder and chief executive of IT Governance, which is a business I set up about 15 years ago in order to be a single source supplier of everything that organizations might need to tackle IT governance, cyber risk, IT compliance, and data protection. By everything, I mean everything in the people and process domains. And the origins of the business were in a book I wrote called IT Governance, an executive guide to, or now an international guide to data security in ISO 27001, which has been the Open University postgraduate textbook ever since its second edition, and it was in a pretty roundabout way the cause of the foundation of this business, which now operates across a very broad range of governance, risk management, and compliance fields. The heart of our business is what we increasingly call cyber resilience, and that is the combination of compliance, data protection, compliance, GDPR and related regulations, cybersecurity and ISO 27001, with related standards like the PCI DSS, but combined also with business continuity management and international standards in that field. The combination of those enabling an organization to deliver assurance that it's genuinely cyber resilient. And we deliver our services through a combination of consultancy, technical security, training, software tools, books and toolkits, and any mix of those that works for clients. We're going to be talking today, though, about the General Data Protection Regulation. We're going to start off with an overview of the regulatory landscape. We'll look at the principles of the European Union's GDPR, which is now included in the UK's new Data Protection Act. We'll look at breach notification rules, data subject rights, changes around consent, the role of the data protection officer. We'll touch on international transfers and the role of the European Data Protection Board in arriving at or in ensuring some form of a level playing field. It's almost always the case that people on these webinars have a number of questions that you want to ask, and you will have noticed that you're on mute. That's designed to make sure we don't have too much background noise disrupting the occasion for everybody. But please do use the questions section of the GoToWebinar panel, which will be on the screen somewhere in front of you. If you click on that, there'll be a screen into which you can type your questions. Do feel free to put questions in there at any point as I go through the webinar. The webinar itself is designed to run for about 45 or 50 minutes. And when I come to the end of the prepared section, there'll then be 5 or 10 minutes left over in which I'll tackle as many of the questions as you've asked as I can in the remaining time. I'll read the question out and then I'll provide the answers so everybody knows both what the question was and the answer was in case it was something that also affects them. So that's the plan for today. I'm going to start off by recognizing the difference between the two normal forms of law under the European Union. The first is what's called a directive and the other is a regulation. A directive is where the European Commission gives the governments of its member states a directive that says they must put in place in their national legal structures a law which achieves a minimum set of objectives and which works in a minimum way, but leaves it open to the member states to determine how they do that and allows them, of course, to go further than the minimum requirements set out in the directive. At the moment, the Network and Information Security Directive, which applies to online service providers and to critical national infrastructure, is an example of an EU directive. It came into force in the early part of May 2018. A regulation, on the other hand, goes into law as written goes into law in member states, irrespective of whether or not the member state government passes a law itself. And the General Data Protection Regulation, as the name suggests, is exactly that. It doesn't depend on member states passing a law for it to become law. It becomes law by virtue of the European Union treaties. In the United Kingdom, in order to give organizations a sense of certainty beyond the supposed date of Brexit, and also in order to put into place some of the derogations which GDPR makes available to member states, the UK government has passed the Data Protection Act, which was signed into law on the 25th of May 2018, exactly the same date that the GDPR came into effect across the European Union. So we're dealing with a regulation. It's the same law written across the whole of the European Union. And essentially, what this law is saying is that data subjects, and that's you and me, it's individual natural persons, we have rights. And under the model for data protection under GDPR, we share that information with a data controller, and we share the data with the data controller if we see a good reason to do so. The data controller has to have a lawful basis for collecting data, and the data controller can outsource some or all of the processing of that data to a third party, which will be defined as a data processor. So the data controller is the key entity from a GDPR framework perspective. The Information Commissioner's Office in the United Kingdom is the UK's supervisory authority, is charged with ensuring GDPR compliance across the UK. Its primary focus is on the compliance behavior of data controllers. Data controllers will almost always be organizations or partnerships, as the case may be, but will mostly be legal entities dealing with the data of natural persons, of data subjects. The data subject has rights, and therefore data controllers have duties in respect of those rights. The ICO, as I said before, their role is to enforce GDPR and to make sure that the security that's appropriate to the protection of data is applied by controllers to their relationships with third-party processors, and that where data is transported outside of the United Kingdom, it's subject to appropriate security, but also to appropriate guarantees of access to European Union, EU-type law. GDPR allows data to be provided to third parties to be shared. There are particular requirements around how that is done. The data subject's entitled in many instances to know how data has been shared, and it is of course still possible to acquire data about individuals from third parties, but there is an obligation to tell the data subject where you got their data from. So that's the model of data protection in the European Union, all of it overseen by the European Data Protection Board, which also came into existence at the end of May. And its role, it's not a super authority, its role is simply to ensure that across the European Union as a whole, the GDPR is applied in a consistent way. So it deals with interpretation of those parts of the law which are not clear. It deals with ensuring that fines are applied equally. All of those things that were missing from the data protection directive environment, which we've just left. The previous, as we now say, data protection regime across Europe was based on the data protection directive. So there were 28 different versions of implementing that directive, which meant there was a very uneven playing field both for data subjects and for controllers in determining what they had to do to be compliant, and they could have compliance problems in every single one of the countries within which they're trading, and those problems might be different in each of those countries. So, as I've said a couple of times, the subject of GDPR is natural persons. Natural persons, that's living individuals. Deceased people do not have rights. Entities, legal entities, a company, for instance, does not have rights under the Data Protection Act. And natural persons have rights to the protection of their data, to the protection of how their data is processed, and to the unrestricted movement of their data within the European Union. The data that's within scope for GDPR is really two types: personal data that is processed partly or wholly by automated means, or that is or is intended to be part of a structured filing system. So in simple terms, if you have a pile of business cards sitting in a corner of the desk, that's almost certainly not a structured filing system. It's not being processed by automated means, so that data does not need to be subject to GDPR. But if you put those business cards into a Rolodex, or you process the data into a CRM system, at that point it comes within scope for GDPR. So at that point you have to do what GDPR says in relation to that data. And understanding these kinds of technical aspects around the law is of importance in helping you make sure that the way you implement GDPR doesn't give you something which is unwieldy and complex and gets in the way of operating the business effectively. If you're a controller or processor based in the European Union, you have to comply with GDPR irrespective of the place of residence or nationality of the data subject. So if you're an e-commerce business operating out of the UK and your customers come from 190 different countries around the world, they're all entitled to exactly the same protections as are the EU citizens amongst your clientele. So if you're a controller or processor in the EU, you're subject to GDPR. If you're a controller not in the European Union but providing services into the EU, you also have to comply in respect of those services. That doesn't mean that you have to comply just because somebody in the EU comes to buy something from you. GDPR is very clear that the provision of services, the acquisition of services by an EU resident on a chance or ad hoc basis when, as an organization, you are not providing services, does not put you under compunction or under the onus of compliance with GDPR. And those of you who are paying attention will have seen on the 23rd, 24th, and 25th of May, many organizations saying, well, we don't want to take the chance that somebody might come and contact us from the European Union because it's too expensive to comply with GDPR. And they were, frankly, simply ill-advised and therefore made a bad business decision, closing their business off to the European Union when they weren't actually providing services into it. So you have to provide, if you're outside the European Union, you have to be compliant in respect of the data of the data subjects within the EU. And if you don't comply with GDPR, there are penalties, and the penalties are administrative fines up to, for the lower tier, up to 2% of global turnover or 10 million euros. And for the core areas, that's breaches in respect of data subject rights, in respect of international processing of data, and in respect of the 6 data processing principles, fines can go up to 20 million euros or 4% of global turnover. And those fines are meant to be painful, but they also have to be proportionate. That means that if you're an organization turning over 5 million euros, you can't possibly be fined 20 million euros. It would be completely disproportionate. Fines have to be proportionate to the organization and to the offense, even though they're intended to be dissuasive. It's also worthwhile stressing that these fines that you see, and you may have seen in the press, are maximums. The supervisory authorities are able to apply fines up to this as a maximum level. That's not the fine itself. The fine has to take account of the level of negligence inside the organization, and it's highly unlikely that certainly in the first year or two there will be many fines anywhere near the top end of what might be possible, because with a bit of luck, most organizations will be able to demonstrate that even though they have got something wrong, they've made appropriate steps to do as much as they can to apply best efforts to get compliant as quickly as possible. GDPR, as you may know by now, came into force on the 25th of May, 2018. It was published in the official journal of the EU on the 4th of May 2016. It came into force on the 24th of May 2016. It became law in all 28 member states on Friday, the 25th of May. So in theory, during that 2-year transition period, most organizations made the transition from Data Protection Directive to being compliant with the GDPR. In reality, we think that at the moment, probably 75% or more of the UK's businesses are still not compliant with GDPR. Many of them may not even have started on the journey. So if you're on this webinar because you've just realized you need to get compliant and you're worried that you might be amongst those remaining few organizations, you're probably not. You're probably amongst the, frankly, the still relatively early part of the United Kingdom that's getting itself compliant with GDPR. And the Information Commissioner has recognized the challenge for many organizations and been very clear that provided that you can show that you're making best efforts to proceed as quickly as possible, you're likely to be able to reduce the size of the claims of negligence against you. But you shouldn't be in any doubt. It is now a law. It has been a law for the last couple of weeks, and we have already seen a couple of organizations who, or at least one organization which exists solely to bring actions against organizations that breach GDPR, launched its first legal actions on the 25th of May against obvious targets like Facebook. So how do you get to be fined? What are the things that lead from you just getting on with your business on a day-to-day basis and finding yourself on the receiving end of fine? And the answer is two things. The first is that you have a personal data breach. The GDPR requires that if you have a data breach which creates a risk to the rights and freedoms of natural persons, you report that breach to the Information Commissioner within 72 hours of first becoming aware of it. 72 hours is calendar hours, not business hours. So if you have a breach on a Friday morning, you're going to be reporting that on Monday. And that's deliberate because, of course, many breaches do take place on Fridays. Criminals know that if they can give themselves the weekend without anybody paying attention, they can probably make more progress in their enterprise than if they do the breach on a Monday. So you have to notify. If you're a data processor and you have any sort of breach at all, you have to notify a data controller within 72 hours. If you're a data controller and there is a risk to the rights and freedoms of natural persons, then you have to notify the Information Commissioner within 72 hours. Now, the average period for an organization to discover a breach in the UK is currently sitting at something like 140 days. I don't think that's a good position from which to be reporting a breach, saying we just found out it happened 140 days ago, but we're reporting it within 72 hours at least. Yes, it's within 72 hours from when you first knew about it, but I imagine trying to demonstrate that it took you 140 days to find out about it, and that is not evidence of negligence, is not going to be that easy. So the imperative to get on top of cybersecurity and on top of being able to identify a breach is, if anything, much greater. So the first way you get into trouble is you have a breach, you have to report it, and it's likely that the Information Commissioner will investigate breaches, particularly if it's a sizable breach or the circumstances of the breach, and you have to describe all of the circumstances of the breach, suggest a level of negligence or a level of exposure for data subjects. An investigation is likely to lead to a fine, not on the basis of the transgression itself, but on the overall level of negligence. So that's the first way you get into trouble. The second way you get into trouble is that data subjects have rights. And the first right that data subjects have, it's not one of the clearly identified rights, but you should recognize its validity, is the right to bring a complaint, the right to bring an action in court, and the right to seek financial compensation for non-financial damages because the confidentiality, integrity, or availability of their personal data has been compromised. And we already see substantial evidence of individuals bringing complaints, individuals saying my data is continuing to be processed by X organization. They've not taken me off their list when I asked them to. This organization keeps on emailing me. I want them to stop. Please deal with them. And that's only in the first week or so after GDPR became law. And those are going to trigger investigations. We're not yet clear whether they're going to be on a sector basis or just the size of the number of complaints, but it's a data subject complaining or bringing an action that will have to trigger a supervisory authority investigation. On a broader level, data subject rights start with the right to be informed about the processing of their data, to know what lawful basis you're processing their data on, to have access to their data to confirm that you're doing what you said you would be doing, to rectify any errors under certain circumstances, to have their data erased. This, like the rights to data portability, is not an absolute right. There are limitations to when it can be applied. The right to restrict the processing of data during a period within which there is a discussion taking place over the grounds of objection, and the right to be informed of the existence of automated decision-making, including profiling, as well as the likely consequences of that. So data subjects have the right to all of those. The right, if the lawful basis of processing is consent, the right to withdraw consent at any time on the basis that when they withdraw consent, you will stop processing their data. The consent as a lawful basis has a number of other challenges, and I'll touch on those shortly. So the three areas, if you remember, in which the higher level fines apply are the rights of data subjects. We've just looked at those. The transgression of the 6 data processing principles, which you see set out here in this slide. And when you think about these principles, really the first one to be thinking about is the second principle, because if you're collecting data for specific, explicit, and legitimate purposes, it's likely that you'll be able to very quickly get to the point where you comply with the requirements of the other 5 principles. Direct marketing is a legitimate purpose. It's perfectly legal to collect data and to carry out direct marketing activity, and just as it's perfectly legitimate to buy data from data brokers, to buy email lists. What you have to do, though, is comply with the law when you do that, which means that you have to be clear about the grounds on which people allowed themselves to be put onto a data list. You have to tell data subjects where their data came from. You have to, if you have a legitimate interest, be clear on what the legitimate interest is and document it. So compliance with the 6 data protection principles is important. Even more important is compliance with what GDPR in effect calls the 7th principle, which is the principle of accountability. And that's the ability of the organization, of the controller itself, to demonstrate that it complies with all 6 of those principles. And the ICO, when talking about the idea of accountability back in January 2017, made the point that GDPR was about mitigating risk to the rights and freedoms of data subjects. It wasn't just about ticking boxes, it was about building a culture of privacy that pervades the entire organization, mandating organizations to put in place comprehensive governance measures, changing culture, an overall systems approach to how it manages and processes personal data. It's inconceivable that an organization could do this effectively without top-down board and senior management involvement, without GDPR being regularly on the board agenda, with GDPR compliance being something that the board pays as much attention to as it does to financial probity and financial compliance. At a proper privacy compliance framework, the application of the principle of accountability would be reflected in a corporate risk register, which sees privacy risk as one of the risks on the register, but not just the risk to the organization of a breach, but also risks to the individuals themselves. There'd be a nominated accountable director, clear roles and responsibilities through the organization for data protection, with, where required or where appropriate, the appointment of a data protection officer or of a GDPR compliance officer. The building of a privacy compliance framework, which would blend a privacy information management system with an information security management system, which would map your data processes so that you've got a proper record of your data processing, so that if there is a breach or a data subject access request, it's relatively easy to identify where the data is and what you're doing with it. Cyber incident response and data breach reporting process, and appropriate security. And in the UK, at least, Cyber Essentials would be a minimum external security standards to be able to point to. It's the way that you can demonstrate that you put in place the 5 technical controls, which would at least deal with some 80% of common internet-borne attacks. And most organizations ought to have Cyber Essentials, which is now a prerequisite for UK government contracts as part of their basic defense mechanism. We'll see the emergence of data seals, certification to standards like ISO 27001 becoming more common as mechanisms for demonstrating that the organization has taken appropriate steps to meet its GDPR security, data protection, compliance requirements. GDPR certainly asks that data protection be embedded by design and by default. That means that you will need to be doing, particularly around high volume processing of special categories of data, processing of data in a public place. You'll need to be doing data protection impact assessments, where you're combining systems in a way that is likely to create new risks to data subjects. A DPIA will be mandatory. And in fact, if you if you have a planned process of embedding data protection, it'll become a core part of thinking about how process evolves. It'll become a core part of IT development projects, of hardware projects. Will be the question about what impact will this have on the rights and freedoms of natural persons? What steps should we be taking to minimize those impacts? So a data protection impact assessment is said good practice in many instances, and for a small number of organizations, it's mandatory, just as is the appointment of a data protection officer. Let me come back now to lawfulness. I touched on consent. GDPR says in Article 6 that you must have a lawful basis for processing personal data, and it provides half a dozen options, half a dozen ways in which an organization might be able to demonstrate that it meets its requirements to have a proper lawful basis for processing data. And those options start off with consent, but they continue to list processing in the vital interests of the data subject, processing because it's necessary to fulfill a contract with the data subject, processing in the legitimate interests of the controller. And so when you look at it, consent isn't the only basis of processing. In fact, in many cases, it shouldn't even be on the possible list of lawful basis. So if you employ staff, for instance, you should not be processing their data on the basis of consent. You have an employment contract with them, and you should be processing all of their data in order to fulfill the contract, in order to meet your legitimate interests as an employer. Some of the data you'll need to process in order to comply with your statutory obligations to collect, for instance, HMRC data, and there might be information which is necessary for you to keep in order to deal with law cases. Those are all lawful bases for processing data. The problem with consent is that if you're processing employee data on the basis of consent, it's already identified as being invalid because of the unequal relationship between employer and employee. And in any case, data subjects can withdraw consent, which would make it difficult for you to continue employing them, but you've still got a contract which you can't breach just because they withdraw consent. So the consent bar itself, as we'll see in a minute, has a very high bar and is inappropriate. Many of you may have had emails coming from people on whose list you didn't even know you were in the week or so before May the 25th, asking you to reconsent to the processing of their data, and in most cases that was wholly unnecessary. They needed to have told you the basis on which they were processing your data, but they probably didn't need to seek your consent. They probably already had a legitimate interest basis or a statutory basis or some other basis that would have given them a lawful ground for continuing to process. It's a very important part of your GDPR program is working out what the lawful basis of the processing of each of the different types of data is that you've got. And you're a controller, which means that you're going to make the decision about processing data in a number of instances. The definition of a controller is the entity that determines the means and purposes of processing, and the processor is defined as a third party that processes on behalf of a controller. So the assumption of GDPR is that in many instances controllers will be doing their own processing, but they can outsource it to a third party. If they outsource it, there must be a contract between the controller and the processor. There's a legal obligation. A processor, an organization can't say, we're not a controller, we're a processor, unless it's got a contract and wants to be compliant with the law, unless it's got a contract with a controller. So consent. Not only is consent something that can be withdrawn, the bar for demonstrating that you had consent is very high. Consent has to be given positively. It has to be in response to clear, evident, transparent information about what it is they're consenting to, and it has to be granular. So pre-ticked boxes on a website of the untick this box if you don't want to hear from us are illegal. You have to, saying to somebody, you have to consent to the processing of the data for purposes of marketing in order for us to allow you to access your emails would be illegal. You have to provide a granular basis. So you'd have to say consent to the processing of your email for the purposes, processing your personal data for the purpose of email, tick yes or no, processing your personal data for the purpose of marketing, tick yes or no, and a data subject could be able to say yes to the first and no to the second without penalty. So very tough, has to be thought through clearly, and in most instances an organization should be looking at alternatives to consent rather than just going blindly for consent because that's what you've always done. It's harder for children under 16 or in the UK under 13, where it's illegal for the person to give consent for the processing of their data for the purposes of an information society service. It's not all data. This is only for services such as social media, e-commerce websites. Somebody in the UK under the age of 13 cannot legally consent to the processing of their data in those circumstances. Doesn't interfere with their rights to consent under other circumstances. It applies only to that narrow range of activities. That means that your 12-year-old child can't, of their own accord, sign up for a social media account. They have to have the permission of an appropriate adult, and that means that organizations that are likely to have children signing up for services have to have a mechanism for establishing that the person giving consent is indeed an appropriate adult and not just another 12-year-old. There's also a prohibition on the processing of what GDPR calls special categories of data. Under the Data Protection Directive, we call them sensitive information or sensitive data. But special categories of data is anything to do with race, ethnic origin, political belief, trade union status, biometrics, genetics, and so on. And GDPR says that processing that kind of data is prohibited unless, one, you've got a proper lawful basis from the list of options set out in Article 6, and two, you can point to an exception to the prohibition of those set out in Article 9. Article 9 includes the explicit consent of the data subject, but it also includes vital interests of the data subject. It includes processing necessary to performance of a contract between you and the data subject, and a number of others. So you can potentially have a situation where the lawful basis for processing and the exception to the prohibition are either the same or very similar, but you need to be clear that it's 6 and 9 to process any category of special data. So challenges for many organizations around Articles 7 through 9. With a bit of luck, not so many challenges around Articles 12 through 18, which are all talking about transparency. And in principle is saying that any communications you have with data subjects must be transparent, concise, intelligible. You must be clear in providing information about what you're doing with the data. You must give data subjects information if they ask for it within 1 month. You've got a month to respond to a data subject access request, not 30 days, not 28 days, but 1 month. You can't charge them for making a data subject access request. You are entitled to ask them to give you some guidance as to what it is that you want to know about. You're also entitled to ask for some evidence that they are who they say they are, because on the other hand, you're not allowed to disclose data to people who have no right to see it. So you have to be transparent with data subjects. You also have to help them exercise their rights, this rights of data portability, to restrict processing, and so on. You have to facilitate the exercise of those rights, which means that you need to describe them in your privacy notice. You need to tell data subjects what they can do so that you can help them to exercise those rights. And exercising rights really is, if you like, a significant part of what data protection by design and by default is. Building data protection into your processes, making sure that they work as you want them to, puts you in a strong position to be able to meet data subject access requests quickly and easily without discovering that you're transgressing the legal requirements. But data protection by design also means that if you're dealing with processes, or if indeed you're a controller outside the European Union, you too must comply with GDPR. We saw that in terms of the territorial scope of GDPR, but it's also the case that if, as a EU resident controller or processor, you're sharing data with an organization outside the European Union, you need to make sure that they are compliant, they sit within an area that for which there's an adequacy finding, and we'll look at the international aspects shortly. Data protection impact assessments, again, we've seen a mandatory where your processes are likely to result in a high risk to the rights and freedoms of data subjects. And all of that leads into not just the requirement for data protection policy, but the carrying out of data audits. Data audits will become, for all organizations, at least an annual event. The requirement is very clear that you need to be able to demonstrate that you're continuing to meet your compliance requirements from a board perspective. That means an audit. You may have to, because of where the organization is now, your audit, your gap analysis may identify lots of weaknesses which you now need to go and close down. But fundamentally, your audit should be confirming that where you hold data, what you're doing with it, how secure it is all in line with your obligations under the GDPR. And one of the key obligations, as we've seen, is that you protect personal data. It has to be kept in a way that is secure. And that's set out both in Article 6, which is looking in the sixth principle at the obligation to protect personal data, and also in Article 32, which is looking really at the organization's overall obligation around systems and processes to secure data. Now, the challenge is that what Article 32 says is the organization has to have in place appropriate measures to meet its obligation, which reflect the level of risk and the state of the art. And of course, those are phrases which are not yet defined. So in terms of identifying what appropriate steps are, you are stuck. You don't have a legal standard to go to, which is why most organizations will turn to standards like Cyber Essentials and ISO 27001 as being external standards against which you can have an external audit that validates the level of your compliance to the requirement to protect personal data. Encryption and pseudonymization should become increasingly part of how you approach data. There is a difference between anonymization and pseudonymization. Don't confuse them. Encryption, on the other hand, is a very straightforward technological mechanism for rendering data inaccessible to those who don't have the access key. And in most cases, the fact that data is encrypted will mean that even if there is a data breach, there will be no obligation to report it to the ICO because the data is not exposed because it's encrypted. So data protection by design needs to be reflected in all of your security processes, and that needs to enable you to demonstrate that personal data really is genuinely protected. And your privacy compliance framework pulls together all of those elements. It pulls together the role of the board in terms of governance and risk management. It looks at how you tie the 6 privacy principles into the policies, procedures, controls, and records that indicate you're taking appropriate steps to identify, protect, and manage the data of all of the data subjects with whom you deal. The building of a privacy compliance framework is a longer-term activity. For most organizations, the initial step is to get the key elements of GDPR compliance in place, and then to build as quickly as possible a comprehensive and solid privacy compliance framework which embeds data protection in the organization. For a number of organizations, the data protection officer will be mandatory. And that is the requirement is set out in Article 37. If as an organization you're processing high volumes of special categories of data which is core to your business process, if you're processing high volumes of data of people in a public place, or if you're a public authority, you will have to have a data protection officer. Data protection officer is a protected role. You can't fire somebody because you don't like their advice. You can obviously fire them for breach of contract or for turning up late, but you can't fire them for their advice. It's a protected and regulated role from that perspective. You can have a data protection officer who's an employee. They can be a part-time employee. They can work across a number of businesses. You can take a data protection officer as a service from a company that specializes in providing that kind of service. GDPR provides all of those options for organizations. It does set out a number of very clear requirements for what somebody has to be able to evidence if they are to be a data protection officer. You can't be a data protection officer just because you've done a one-day GDPR training course. Data protection officer requires significantly more knowledge and experience to be able to do that. Outside of the mandatory appointments, a data protection officer is a good idea. Certainly for most organizations, a GDPR compliance manager is likely to be a smart thing to do. Remember that if you appoint a DPO and you don't need one, they're still subject to the requirements of a DPO set out in GDPR. So you need to think about titles if it's not a mandatory appointment. There are many other people inside the organization who will need training on the GDPR, HR, marketing, sales, IT, legal. All of them will need to understand their roles and responsibilities around data. And in fact, everybody through the organization who's likely to handle data needs to understand their obligations. After all, a data subject access request can be made verbally, can be made simply to the person on the switchboard. There's nothing in GDPR which says that it has to be written to a given individual. And so you want everybody through the organization to recognize the data subject access request, to be able to provide advice to data subjects, and also to be aware of their obligation to protect data. An accidental release of personal information is as much of a personal data breach as something which takes place because of a cyber attack. I've touched on the idea of certifications before. They're a practical way for organizations to demonstrate that you've taken appropriate steps to meet your compliance obligations. GDPR specifically allows for certifications like ISO 27001 to become standards which demonstrate that because there's an external audit, you've taken appropriate steps to meet your GDPR compliance requirements. Codes of conduct, BS 10012 is a standard for personal information system, but there will certainly be the emergence of new privacy seals and standards across the European Union in the years to come, and organizations should keep an eye out for those to see how they can help you demonstrate compliance. Key thing with certification, of course, is that it's not going to be certification that you comply with the law. It's going to be certification that you comply with a compliance scheme. The ultimate decision as to whether you're complying with the law or not is always going to be a law court. GDPR is a law, and compliance ultimately is going to be decided when there's a contest by the European Court of Justice. International transfers in this day of cloud-based services. More and more organizations trade across borders. They use apps which are provided by organizations in Australia or America to collect data from data subjects in the European Union. All of that's fine as long as the processing of the data outside the European Union meets the requirements of Articles 44 and the ones that follow. And that says processing outside the European Union. Processing includes somebody just looking at the data or storing the data is only legal if the country within which it's being stored is recognized as having an adequate data protection regime. There are only about a dozen of those, and they're all listed on the European Commission website. Or there are appropriate legal safeguards in place in the form of standard contract clauses or inside larger organizations binding corporate rules. And absent those, you are potentially in trouble. The United States is a country that is not on the list of countries having an adequate data protection regime. As things stand, it's unlikely to be, and that means the only way in which you can securely deal with data processing in the United States is by ensuring that the controller or process with which you're working is registered under the EU-US Privacy Shield, which was agreed back in July 2016 as providing protection to organizations transferring data into the US. So international transfers is the third of the areas where breaches can trigger major fines, and it's one of the more complex areas because, of course, many of the cloud-based service providers you're dealing with are not necessarily that clear in the terms of their processing, and you could have exposures there without being aware of them. Enforcement of all of this in the United Kingdom, as I said earlier on, is in the hands of an independent supervisory authority, the Information Commissioner. What GDPR provides for is that a supervisory authority can be the lead supervisory authority for an organization across the whole of the EU. So you could, as a UK organization operating in a dozen different countries, choose the ICO as your supervisory authority, and that means all of the enforcement activity will be channeled through the ICO. It doesn't mean it has to be. There's nothing that prohibits the German or French supervisory authorities from dealing directly with you, but on balance, it should mean that you're able to channel and organize your compliance activity in a much more structured way. For those of you thinking ahead to Brexit, the United Kingdom will, after Brexit, be outside the EU, and that means that it will have to, it will have to meet an adequacy requirement if data is to be moved from the EU into the UK, or there will have to be some other framework in place. And all UK organizations providing services to the EU will need to appoint a representative inside the European Union. So one of the many ramifications which perhaps nobody thought of at the point of the Brexit vote. Sitting above it all, as I indicated, is the European Data Protection Board. Their role is to make sure that the application of GDPR is consistent across the European Union, to make sure there is proper communication between the supervisory authorities to deal with questions which come up as to what do particular terms and phrases mean before they become subject to legal argument. So a significant role in ensuring the existence of a level playing field. So here you are, it's the 6th of June. It's now some 10 or 11 days since GDPR became law. What do you do? Well, the ICO spoke about accountability, encouraging an upfront investment in privacy fundamentals, makes the point about protecting data, makes the point about the big stick which she has to weld, but fundamentally what she's saying is it's about accountability, about making sure that you recognize what you need to do. And if you're only starting on GDPR right now, the best place to start is with the board agenda, is with the board recognizing that it has an obligation to meet GDPR compliance requirements and putting in place a plan that enables you as quickly as possible to protect data. That's obviously the key thing to be doing, to protect data from breach, theft, or loss, to enable data subjects to access their data, and then to move as quickly as you can into the other areas of compliance. In fact, there are 9 steps, and we've now helped 500 or more organizations tackle their GDPR compliance through our consultancy arm. Is get your governance framework in place, get a risk register, build an accountability framework, and appoint either a data protection officer or a GDPR compliance officer who's going to own the implementation of GDPR. Do a data inventory. Who's processing data on your behalf? What data have you got that you shouldn't have and that you should be destroying? Do a detailed data flow audit. Having identified the chunks of data you've got, work out how data flows between them. Look at the gaps that will expose between what GDPR requires and what you're actually doing. The gap analysis will probably identify changes you need to make in terms of your privacy notice, your data subject access request documents, in terms of the robustness and legality of the various processing, and will contribute to the creation of your records of processing. You need to look at security gaps. This might involve, in many organizations, a data protection impact analysis. It certainly is about looking at security gaps. And out of those 2 gap analysis activities flows a whole series of remediation activities, which over time build out into a privacy compliance framework, which is badged at the security level with external certifications such as Cyber Essentials, ISO 27001, and so on. You also need to be developing an incident response and data breach reporting process. You're going to have data breaches. That's got to be a given. So you need to know how you're going to respond to them, how to identify them, and how you're going to report. And again, you can buy data breach reporting as an outside service, but the key thing is you need to know how to get hold of the ICO, what the reporting process looks like, how to record what's happening while you're doing it. And as you embed GDPR, you need to start putting in place a continual improvement, monitoring and auditing framework that ensures that your recognition that GDPR is not a destination, it's a journey that now becomes part of the onward evolution of the business, is something which as a management you can stay on top of. As an organization, we do quite a lot to help organizations, other organizations tackling GDPR. We're obviously ourselves GDPR compliant, although we know perfectly well that we'll keep on identifying ways in which we're not as good as we think we are and we need to take steps to improve it. But we have a pocket guide, we have an implementation manual which give you useful guidance on how to tackle GDPR. There's a documentation toolkit, a gap assessment tool, which with a bit of training anybody can use. And those are relatively easy, quick, simple ways of first steps towards GDPR compliance. We have a whole series of training courses. We have a foundation course for GDPR, which is delivered in a classroom, delivered online, live, or in the form of distance learning. Also a practitioner course, so somebody who needs to get a good handle on GDPR in a 5-day practitioner course can certainly do so. Data protection impact assessment workshop for organizations where DPIAs are either mandatory or a practical part of what you've got to do. And of course, if what you want is help, then our consultancy business, our one-stop shop, can help you with a gap analysis. We can do data flow audits, data protection impact assessments. We can help with implementing a PIMS or an ISMS. We can do cyber health checks. We can do penetration testing. We can help you deal with your PCI compliance. All of that is part of a joined up privacy compliance framework. And of course, we'll go on delivering webinars for people who are early in their compliance journey, people dealing with specific issues and related subjects. And so you can go to itgovernance.co.uk/webinars page. You can sign up for any of the webinars that there are. You can make contact with us and talk to GDPR experts, or indeed any other expert that you want to about initiating compliance projects. And that brings me to the end of what I'd prepared to say. So we've now got some 9 or 10 minutes left, and I'm going to tackle any questions which you've got. Remember, if you have questions and you want to ask them, the simple way to do them is to take the Q&A box, which is in the GoToWebinar panel, type a question in, and I'm going to work through the questions. I'll read the question out and then I will share the answer with you, and I'll get through as many as I can. So we're a manufacturing company. Do we need a data protection policy for our business customers? Yes. Insofar as the business customer is a corporation, no, because entities don't have rights, legal entities don't. But you'll have people representing those entities, so you'll know who the name of the buyer is, of the purchase ledger manager, all of those people. You have personal data, and even the fact that it's a business email address doesn't change the fact that it's personal data. So you will need to deal with that personal data as required by GDPR. Under penalties, what's the difference between point 2 and point 3? Penalties, point 2 are lower level things, so failing to embed data protection by design by default, failing to report a data breach. There's a long tariff of items which merit the lower level of fine. The only core areas that merit the higher level of fine are breaches of the 6 data processing principles, breaches of data subjects' rights, breaches around the requirements in terms of international processing, and of course failure to cooperate with a supervisory authority. If you're a US-based company that receives information from an individual located in the EU, that does not automatically subject you to GDPR requirements. Yes, that is correct, unless you are providing services to the EU. However, when you, for example, add that person's information to your mailing list and then monitor whether that person opens the weekly email, yes, at that point you're providing services. And there are set out in GDPR a number of examples of what providing a service might look like. If you are deliberately and consciously collecting data from EU citizens in order to send them information, paid or unpaid, or anything else, then you fall within the scope of GDPR. So it's worthwhile thinking about how do we maximize. There is a cost to compliance, of course, but given that some American businesses think it's too expensive, there is obviously a commercial advantage in deciding to make sure you're compliant and going hard at winning business in the European Union. What is automated decision-making means? So An organization that is, for instance, deciding whether or not you're allowed to get a mortgage and does that all by means of an algorithm, that's automated decision making. You put a whole lot of information in, it draws on the information you provide, it collects data from a credit rating agency, and then you get a message back saying, no, you're not going to get a mortgage. That's automated decision making. If anybody's told you that a data subject access request must be in writing, then you need to suggest they go away and read the GDPR. They'll find there is nothing that says it must be in writing. It simply says data subjects are entitled to make a subject access request. That means they can do it any way they like. They can do it in writing, orally, and you need to be in a position to be able to identify that. Of course, you're going to encourage people to make it in writing because you want to have control over the process. You want to have it auditable and trackable, but there's nothing in GDPR which says a data subject access request has to be in writing, and I would encourage you not to follow the advice of anybody who tells you otherwise, unless they can point to the clause which disagrees with what I'm telling you about. Why is the principle of accountability separated from the rest of the principles? Because accountability applies to all of them. The other 6 are independent, discrete principles. Your compliance with each of them can be tested individually. In other words, you can say, is the data being kept securely? Yes or no. Is the data accurate for the purposes which is required? Yes or no. They're not dependent. But the principle of accountability applies to all of them. As an organization, you have to be able to demonstrate that you have recognized your obligations to apply all 6 of them consistently and are doing so. Exactly what is meant by a data subject? Is it only a citizen of the EU? No. A data subject is defined explicitly as a natural person. The scope of GDPR isn't natural persons. The scope of GDPR is driven by the location of the data processor or data controller. So if you're a controller based in the European Union, within scope for your GDPR compliance activity is the personal data of all natural persons anywhere in the world, irrespective of nationality or place of residence. Yep, somebody temporarily resident in the EU, short length of study, if you're processing their data and you're in the EU, their data is subject to GDPR because you are. When talking about cloud-based services, there's a lack of clarity on whether businesses are protected if they use Google Drive to collect some level of personal data. I would suggest that you shouldn't be trapped or caught by the idea that there is necessarily protection. You as a controller, even a small business, have to determine whether or not the way in which you're processing data is within the requirements of GDPR. In other words, is your Google Drive based within the European Union? Is it being hosted in the EU? And is it being protected in a way that you want it to be? You have to make sure that this is the case. You can't just assume that because it's Google, it will be. If there's a breach and you go, it must be Google's fault, and Google have written a very clear statement which says, no, it's not, then you have a problem you don't necessarily want to deal with. My 92-year-old aunt's care providers log all carer visit notes on a website. I'm a family carer and asked for access to notes and to be able to feedback any problems for my care cover. My aunt has been asked to pay 5 months to enable me to access the website and to read add notes. We have not had any notification of the introduction of the system. A couple of months ago, I don't know to whom the information of the website written by carers is shared. Should this be made explicit? Yes, it should be made explicit at the very least to your 92-year-old aunt, assuming that she doesn't depend for, assuming that she's mentally capable. She is a natural living person. She's entitled to know what's being done with her data. She's entitled to know the basis on which it's being processed. I would suspect that the legal basis will be because the carers have a statutory duty, perhaps. It might be that you have contracted with them, or the state's contracted with them, in which case that's possible. But at the very least, there will need to be a information provided to the data subject. So go back to the website as your starting point, tackle the website and say, I am the niece and I am the legal guardian of my aunt, or get your aunt to write it and say, this is what I want to have happen. I want to know what my data is, who's processing it, and the controller who's got that data on the website or if it's the social services who might be the controller and the website's the processor, have to then tell you. I have a question. What's the most GDPR compliant method to provide data when a subject requests it? Well, provide them with the data that they're entitled to see and provide it to them securely, and provide none of the data that they're not entitled to see, and do it all within 1 month. Will fines be imposed if the data breaches and the supervisory authority is informed within 72 hours? Yes. Or to put it another way, not necessarily. It's a legal requirement that you notify within 72 hours. A failure to do so is itself an offence. So the failure to notify might mean you have one offence. When the investigation comes along, or what you report identifies 5 other offences, all of those could be aggregated to arrive at the total value of the fine, which is going to be then levied on you. Can you clarify, if you don't have a DPO, you should have a GDPR compliance offer instead? Yes, so there are organizations for which a DPO is mandatory. It's not mandatory to have anybody in that kind of a role outside of that. It's simply good practice. The reality is that if you're going to deliver on your accountability requirement, if somebody's going to make sure you are complying with your obligations, then each organization will need to have employed or access to somebody who owns your GDPR compliance in much the same way as you deal with health and safety inside the organization. We're just about to run out of time, ladies and gentlemen, so I'll just pick up 2 more questions, and then I'm afraid we're done. Is a vehicle registration mark or number plate a personal data? Yes, because it identifies a motor car, and a motor car has a registered keeper, and DVLA has the address of that registered keeper, so bingo, it's personal data. Sorry, how about private golf clubs? If they're members, do you still have to break all the data down in the GDPR form? Yes, a private golf club is a controller. It's collecting the data of its members. It determines the means and purposes of processing that data, and so it has to comply with GDPR. And its members are entitled to have to exercise their rights, just as are any other data subjects in relation to any other data controller. There is no entity, not a private club, not a charity, not a public authority, that is exempt from GDPR. I'm afraid, ladies and gentlemen, that brings us to the end of today. I'd like to thank you all for being on our webinar. I hope you found it useful. As you're tackling your journey to GDPR compliance, please do feel free to come back to our websites. Please do feel free to take advantage of our training, our toolkits, our manuals, and of course our consultancy to help you. And of course, you'll want to be moving as quickly as you can now to demonstrate that you're meeting your accountability requirements under GDPR. Thank you all for being here, and good luck in your journey. Good afternoon.